Hello, everyone. We're going to go ahead and get started now. I want to start by thanking you all for joining this community briefing on the new budget bill. With only 2 days notice, over 1,000 people registered for this webinar, which includes affected individuals, community partners, pro bono volunteers, funders, state and local officials, and invested neighbors, and many more. When the federal government is attempting to harm immigrant communities, it is just so heartening to see a strong outpouring of support as we all together figure out what comes next. My name is Charlotte Saul, and I'm the Pro Bono Manager at NIJC. Today, I'm joined by 4 colleagues from our policy and direct services teams. Over the next hour, we will endeavor to give an overview of this new budget bill that was signed into law last week, with a particular focus on the impact on immigrant communities and how we and you all can respond. Let me go quickly over the agenda. I will start by giving a very brief overview of NIJC's mission and model. If we could go to the next slide, please. Thank you. I will give a brief overview of NIJC's mission and model, and then I will hand the baton to my colleagues Azadeh, Jesse, and Cecilia from our policy team to discuss the bill itself. Then we'll hear from Stephanie Spiro, our Associate Director of Protection-Based Relief, about the impact of this bill on our clients, which is already beginning to unfold. Then we'll turn to what you all can do before opening the floor to Q&A. Please feel free to submit questions using the Q&A function at the bottom of your screen during this presentation. And I will note that this webinar is being recorded and will be circulated to anyone who registered once the recording is processed in the next day or so. Moving on quickly to our mission. For those who are new to NIJC, our mission is to establish and defend the legal rights of immigrants regardless of background, and to transform the immigration system to one that affords equal opportunity for all. A little bit more about how we do this. Our model, as you'll see on the next slide, is 4-pronged. It combines direct legal services, impact litigation, policy advocacy, and strategic communications. Our direct services team provides legal aid to over 10,000 non-citizens each year, which we simply couldn't do without the support of over 2,400 pro bono attorneys in our pro bono network. Meanwhile, our policy, litigation, and communications teams advance our mission through systemic channels via the courts, elected officials, public opinion, and more. With that brief overview, I will now hand it over to my colleague Azadeh to give an overview of the bill.
Thank you so much, Charlotte, and thanks everyone for joining us on this really important piece of legislation that has just passed Congress. So I'd like to kick off by discussing the elephant in the room, which is that this bill will cause devastation to communities across the United States, regardless of immigrant status. This means intersecting harms for immigrants and US citizens alike, more poverty, more food insecurity, a worsened climate crisis, attacks on HIV and reproductive care, and more instability as the US is backsliding into trillions more debt while enriching billionaires. What that means for immigrants is really layered harms. Immigrants are also going to be the target of over $150 billion from Congress that has been gifted to ICE, CBP, and the military to terrorize our communities. So let's dig into what that means in the next slide. First, it means a new era of mass incarceration by erecting more immigration detention centers or jails than ever seen in US history. In many ways, this is a watershed moment as ICE has gained the largest budget of all law enforcement agencies, while tearing families apart, while abducting students, attacking longtime neighbors, and violating the US Constitution left or right. Instead of holding ICE in check, Congress is actually handing ICE a blank check, including billions in bonuses, slush funds, and a staggering $45 billion for jails. Second, this bill is also going to allocate more funds for Donald Trump's pet project, which is the building of a border wall, a wall that has proven to be deadly and incredibly invasive, harmful to communities along the border and native rights. along with forced returns of people into Mexico while their cases are pending in the United States in a program known as Remain in Mexico, and fueling the type of summary deportations that are known as expedited removal, where people are being essentially expeditiously sent out of the country without having a day in court, simply, at the hands of the Department of Homeland Security. Third, this bill is going to allocate a staggering, historic $1 billion to the military to engage in Trump's crackdown on our communities. Remember the Marines who were deployed in Los Angeles, as seen in the picture on the right. Remember how the Trump administration has already spent millions on jailing people in a military base in Guantanamo Bay, or using military planes to deport people in the cruelest and most theatrical manner. This funding is going to supercharge these practices and divert even more military troops than ever to wage an attack on our domestic immigrant communities. Fourth, Congress is going to hand states like Texas, who have a proven record of being anti-immigrant and racist in their practices, about $15 billion to join forces with the federal government in terrorizing immigrants. This means more agreements between local police and the feds to do ICE's bidding, eroding any semblance of trust between local populations, including domestic violence survivors, and local law enforcement. It's going to also mean rewarding states for building a wall at their own expense, reimbursing them essentially for those practices, and prosecuting immigrants, despite the clear constitutional concerns that this presents, because as we've seen with Operation Lone Star and other state enforcement practices, there is a clear concern that it violates the Constitution and the separation of powers between the federal government and the states. And last but not least, this bill is going to impose exorbitant fees, quote unquote fees, which are really penalties on immigrants who are seeking relief. It's going to also mean invasive body checks for children, the rapid returns of asylum seekers and children, and essentially turn the clock back on decades of protection for asylum seekers and for children, which had been advanced by Congress with bipartisan support and are now endangered by this new legislation. Now, turning to the next slide. I want to take a moment and talk a little bit more about the impact on kids, because in many ways this legislation is anti-children from the get-go. First, it's plainly clashing with a long-standing settlement agreement that's known as the Flores Settlement Agreement, which limits the use of family detention and sets baseline protections for kids and families who are in ICE's custody and CBP's custody. Now, remember again, ICE is getting $45 billion to build jails. Well, those $45 billion include jailing adults and families, including small infants and babies. Already, the administration has spent about $159 million to reopen 2 private prisons to jail families, including one in which a child died under the Trump administration's first term. Now that this bill has passed, it will open the door for even more of those kinds of jails, while violating Flores and jailing families for weeks at a time. And as you know, the American Academy for Pediatrics recognized a long time ago, family detention inflicts lifelong trauma and harm on children. So this is all happening in our name and with our taxpayer funds. The other thing that's happening with this bill in terms of kids is that it opens the door for invasive checks on children's bodies. Think of the effect on children to be searched by armed law enforcement or people in shelters who are supposed to care for them while they're in federal custody for signs that they are gang members. And how many mistakes are these officials going to make, misunderstanding a sign or a tattoo, as they already have in many cases of Venezuelans who have been forcibly sent to El Salvador? Next, my colleague Cecilia is going to dig into this more, but the bill also is implementing historic fees on relief that children qualify for under US law, including for children who are fleeing abuse and abandonment, as well as kids who are seeking asylum. So it doesn't matter whether or not someone is an adult or a child when it comes to seeking this life-saving protection. Those fees are now part of the equation and part of the reality that they have to face. Fourth, this bill also marks a historic departure from child welfare law because it creates a new process for the summary deportation of children who arrived alone and who, in 2008, a bipartisan Congress determined were highly at risk of trafficking and violence if they were swiftly returned. But now, essentially this bill has created a whole new category in order to carve out the possibility of returning these kids to harm more expeditiously, as the administration has been doing with respect to adults, ignoring again Congress's mandate from all the way back to 2008. And lastly, and I think the photo on the right shows this, we can't forget how much kids are going to suffer as a result of the sheer terror that is caused by this administration. That is US citizen children as well as immigrant kids. As the picture on the right is showing, a child is weeping as her father is mistakenly detained by federal immigration officers in a US immigration court in Manhattan. This happened at the end of the month in June. So we say this often because it's true, but cruelty is the point here, and there's no way that $150 billion to ICE and CBP does not inflict irreparable harm to children. On the next slide, I do want to end on a positive note, which is that we have succeeded in stripping some key provisions from this bill before it became law. NIJC was not alone. We joined a coalition of organizations across different issue areas to fight this bill. And while it passed at the end by one vote in the Senate, which was the vice president, and 4 in the House, we did succeed in actually mitigating some of the harm. And that includes an incredible $8,500 that Congress was going to charge families in order to reunify with their children. With that fee, the government was basically poised to compete with cartels and messaging to parents that if you want your kids back, you better pay us. And that means that for many kids, they would have spent indefinite amounts of time in detention, and desperation was going to take hold inevitably. This bill, it could have been worse again because it basically has prevented the extortion of families by $8,500. That's what I was referring to in terms of, this is what cartels do and this is what the federal government was going to do just in order to get unaccompanied children reunified with their parents. Thankfully, that provision was stripped from the final version of the bill. The second provision I want to highlight is that the fees that, again, my colleague Cecilia will dig into more in detail, actually include have been lowered in many cases, and in some cases, fee waivers have been added. So one concrete example of this is that the original version of this bill included a $1,000 fee for asylum seekers. My colleague Stephanie will break down how even the current fee, which is $100, is still an incredible and impossible barrier for families, but it has been reduced tenfold as a result of our collective advocacy. Similarly, there is a provision now that permits fee waivers for certain fees, including the fees on children who have been abused, abandoned, and neglected. A prior version of the bill did not include any of those safeguards in terms of a fee waiver. And the last thing I'll mention is that there is a reduced role for the military when it comes to engaging in immigration enforcement. So if you remember, I mentioned that the military is going to receive $1 billion, but the original House number for this was 5 billion. So while no amount of money to pull the military into immigration enforcement, attacking our domestic population makes any sense, this is still a significant reduction from where we started. And with that, I will pass it over to my colleague Jesse to dig a little bit more into the details of this bill and detention in particular.
Thanks so much, Azadeh. I'm Jesse Francois, Associate Policy Director here, and I'm really excited. I'm just really glad to be here and so grateful for everyone joining to talk about the impact of this bill and what we expect to come. I'm going to dive into some of the parts of the bill, particularly relating to detention and enforcement practices that we really expect to have a very quick, immediate impact, particularly on NIJC clients and communities across the country. I did want to note, on this slide, I included a picture of a lobby day back in May to show that there has been really incredible, big mass mobilization that has been happening in the months leading up, that was happening in the months leading up to this bill, to show that there was really strong opposition to this bill, and that opposition is going to continue. We're going to continue to mobilize against the worst of this administration in terms of the policies and practices. But some of the numbers from the bill in terms of the funding, the numbers are quite staggering. The bill makes available $45 billion for more immigration jails for families and adults. This is 13 times ICE's fiscal year detention budget. And so the US for years has operated the largest immigration detention system in the world, with over 200 facilities across the country. These are including mega prisons, county jails, and even overseas prisons. There are currently over 57,000 people in immigration detention. This is the highest in US history. And on the next slide, we can see how detention funding has already expanded dramatically over the years, going back just to fiscal year 2005, when it was under $1 billion. And now what we're looking at with this influx of new money, the new $45 billion, we are going to be facing an agency like we've never seen before in many ways. ICE will now be the biggest law enforcement agency in the country. And on the next slide, we break down some of the numbers related specifically to ICE enforcement and enforcement broadly. So there's 30 billion just for ICE enforcement, and this is 3 times ICE's annual budget, which is 10 billion. So this means new agents, new information systems, new contracts with surveillance companies, increased state and local collusion. It includes money for transportation and deportation. There's also over 3 billion for the Justice Department and 5 billion for the Bureau of Prisons. And this means that we'll see an increase in immigration-related prosecutions and also likely an increase in the use of Bureau of Prisons facilities for detention by ICE. The money for there's also money for family detention for parents who are charged for unlawful entry. And it's really important to note this unlawful entry statute. This was at the center of the zero tolerance program from the first Trump administration that was the center of the family separation program. And we know now that Trump administration is already increasing its use of immigration-related prosecutions, and this provision and this bill means that we'll see an increased number of families jailed together while their parents await prosecution after they have been referred for charge for this misdemeanor unlawful entry charge. On the next slide, we get into the numbers around what is provided for CBP, for Customs and Border Protection. First, there's 46 billion for the border wall, for the very wasteful and harmful and deadly border wall. It includes also, on top of that, 11 billion for CBP agents and for detention. Under this bucket, there is 6.7 billion of this is for surveillance technology and for the extreme vetting that Azadeh discussed. This includes the extreme vetting of children and vetting of people upon entry that CBP does. They will have more money for that. There's also $1 billion for the Pentagon. It is for the Department of Defense, but this is what could be used for detaining immigrants, so migrant camps on military bases, which we've already seen. This administration has the intent to increase that. There is another $2 billion for CBP, Customs and Border Protection, just for immigration-related enforcement. This is new agents, and also for extreme vetting, and also the rapid removal without due process that Azadeh mentioned, the expedited removal program. We will see more of that. And then, of course, the more money for state and local collusion from the federal government. On the next slide, we talk about when to expect the impact of the bill. Well, we expect much of this bill to impact communities and NIJC clients right away when it comes to the increase in detention, the militarization, the sweeping arrests, the abductions, the contracts that ICE has already awarded with private prison companies for new detention space in recent months will likely be backfilled by the windfall from this bill that ICE is receiving. And we know that because the Trump administration has already been laying the groundwork for the detention and enforcement expansion. In the months leading up to this bill, the Trump administration already openly acknowledged that they were seeking historic levels and that they were trying to get to enough detention space to hold 100,000 people in ICE detention and try to carry out 1 million removals a year, what they are aiming for. And this is what ICE's budget justification for Congress says that they will be able to do with this money in fiscal year 2026. On the next slide, I just end with a note about the mass mobilization, again, that happened in opposition to this bill for months and months leading up to this. And there has been strong popular and congressional opposition to this bill. There has been a huge movement across groups fighting for healthcare, for labor rights, for human rights. And we will use this groundswell of opposition and continue to push back against the administration's policies and advocate for stronger oversight mechanisms, scrutiny over spending, and we'll continue to urge members to carry out visits to ICE detention facilities, carry out oversight, and new coalitions that have been formed will continue to grow. And with that, I will pass it over to my colleague, Ceci.
Thank you, Jesse. Good afternoon, everyone. I am Cecilia Mendoza. I'm the Associate Director of Government Relations with NIJC. Can we go to the next slide, please? So this bill sets out new or increased fees for different humanitarian applications and also circumstances. And on the slide, we have highlighted only some of the fee changes laid out in the text of the bill. So do keep in mind that fees can still change through the rule-making process, but it is likely that final fees will be at least as high as the statutory amounts that we have here on the slide that we're reviewing today. Of course, it's always important to continue triple checking the correct fees with the corresponding agencies before submitting any applications. The bill text indicates that these changes are supposed to take effect immediately. However, it's important to note that agencies may still issue regulations and or need to create the system for receiving these payments before they actually begin to collect the new fees. And so today we're highlighting the increases and new fees to humanitarian protections, specifically asylum, initial temporary protected status, TPS, initial work permits in certain categories, and special immigrant juvenile status, SIJS. To start, there was no, before this bill was passed, there was no fee to apply for asylum. And now, not only is there an initial filing fee of $100, it added a yearly $100 fee while the application is pending. So every year that the asylum application is pending, there is a $100 fee that individual or family has to pay. And applicants are left at the mercy of processing times. They don't have a way to speed up in its meaningful manner how long the agencies take to process the applications. So they really are left with paying this $100 fee every year for as long as the application remains pending. For initial temporary protective status, filing fees have increased by $450. So now looking at a total, again, for initial TPS applications of $500, with fee waivers only being available when filing for TPS within the immigration court. For initial work permits for people filing based on asylum, parole, or TPS, now all of those bases for initial work permits have the same $550 filing fee, and this bill has eliminated the fee waiver option that used to exist for those applying under TPS and parole. For the special immigrant juvenile status, a relief option for kids that have been abused, abandoned, and neglected, they are now having to pay a $250 filing fee to even submit their application, whereas before there was no filing fee for this application. On appeals, appeals are a way for an individual or family to have decisions from an immigration judge or officers from the Department of Homeland Security reviewed. It's a very important process where people can continue fighting their cases even after a judge or an officer has made a decision on their case. And this fee has been increased to $900. And increasing this fee by such a significant amount is clearly meant to discourage people from considering, or even for, depending on someone's financial circumstances, of even being able to afford to continue fighting their case through an appeal. Fees that didn't exist before related to border and enforcement related fees there are a couple situations that I'll highlight that have now been imposed a $5,000 fee. To start, a person can now be charged a $5,000 fee if they're apprehended between ports of entry without authorization. And there isn't an exception for people who are seeking asylum. Many people, including children, cross between designated ports of entry because these ports of entry are very far apart. So it is something that is seen, that is pretty common. And it's actually not unlawful to seek asylum between ports of entry. Because of this bill, now a person can be charged $5,000 for being apprehended between ports of entry. And now also a person can also be charged a $5,000 fee if an immigration judge orders their deportation because the person missed their immigration court case and for not having appeared in court. Many people are ordered deported in this similar situation because for a variety of reasons, including possibly not even having received the notice that they needed to attend a court hearing in the first place. Other reasons could include language access and not understanding the notices that they were receiving or having lack of access to counsel. And so now those individuals, not only can they be promptly deported under our current system, they'll also be charged, and in this circumstance, an unwaivable $5,000 fee. For some of these fees, like are the fees on appeals and enforcement, there are possible exemptions to these fees and some fee waiver options depending on the facts of a person's case. And this continues to highlight the importance and need for legal representation, legal screening to navigate this system and understand, do I have to pay any fees for my case? What are those fees, as we've seen they're changing and can potentially change moving forward? So having access to a legal screening, having access to legal counsel is so vital to navigating these ever-changing pieces. Even where there are fee waivers available, this is still putting, in particular, low-income families and individuals in a very tight and difficult situation. For example, if a family is coming up to a filing deadline, for example, the 1-year asylum deadline of those who are seeking to apply for asylum, there is a 1-year deadline to submit your application. And if a family is coming up to that deadline, well, now they have to figure out how to come up with these fees. And again, these are individuals and families that have gone through some very difficult situations, may not be able to pay these fees to submit their application, and now have to make a decision of what can I do to make sure I'm submitting my application in time and have the funds to submit the application. And it's very concerning to think about the tough decisions that families will have to go through in order to come up with these horribly high filing fees. The bill calls these fees, and that's the word I've been using, but they function as a wealth tax and punishment for having been born outside of the United States, making protections, and to be clear, protections that were granted under existing US law for the most vulnerable, making those protections inaccessible solely because they are low income. Why else would the US join only 3 other countries in charging people who are fleeing persecution? Why would we charge them a fee for the right to seek protection? Why else would the US charge kids that have been abused, abandoned, and neglected $250 for seeking relief that Congress approved 15 years ago in a bipartisan manner? We are already seeing this wealth tax impact our clients, as we have an upcoming asylum workshop where now our participating 25 families have to come up with the funds to pay for the filing fees that now have to be submitted with their applications. And so I will turn it over to Stephanie, who's going to talk and provide further context as to how this bill is going to be impacting applicants.
Thank you, Cecilia. And thank you, everyone, for being with us today and for your commitment to immigrant rights. My name is Stephanie Spiro, Associate Director of Protection-Based Relief at NIJC. As my colleagues have noted, the reconciliation bill punishes people in our communities for seeking safety, security, and family unity in the United States. Its provisions will directly impact our current and future clients and community members in tangible, significant ways, and it will require legal service providers to react swiftly and decisively to mitigate immediate harm. By way of illustration, I'd like to talk with you about NIJC's former client, whom I will call Evelyn. Evelyn fled Guatemala in 2019 after gang members threatened her and her 4 children when her eldest child refused to join the gang. Though fearful of the journey to the US and aware of increased danger at the border for migrants, she knew that staying home would mean almost certain death for her entire family. As Evelyn told me regarding her brave steps to protect her children, she said, "When I saw my family in danger, I lost my fear." When she approached the southern US border, immigration officials told Evelyn she needed to wait in Mexico for the duration of her immigration proceedings, allowed to cross into the US only for court hearings. Facing a reality of kidnappings, extortion, and trafficking of migrants in Mexican border communities, Evelyn's children entered the US without her and reunited with a family member. For 2 agonizing years, she waited in Mexico, separated from her 4 children, until 2021, when a change in administration meant an end to her forced participation in the Remain in Mexico program. Evelyn was one among over 70,000 asylum seekers subjected to the inhumane Remain in Mexico program under the first Trump administration. Upon returning to office, this administration vowed to restart this policy, and now Congress has bankrolled it. Under this new budget legislation, immigration officials will have a staggering $2 billion for deportations and forced returns at the border, an astronomical amount that could spell horrors for families like Evelyn's at the border. But Evelyn was able to enter the US and reunite with her children. She came to NIJC seeking help with her case. We worked together for several months to assess her legal claim, document the harm against her, and collect evidence. She applied for asylum by submitting an application to the immigration court. During that time, she was able to apply for work authorization to support herself and her children. A year later, she participated in a full evidentiary hearing before an immigration judge. Imagining now for a moment that Evelyn entered the US today, it is hard to avoid feeling overwhelmed by the seemingly insurmountable obstacles she would confront in defending her due process rights and applying for protection from deportation. Perhaps the most widespread and immediate consequence of the reconciliation bill will be the imposition of fees, as my colleagues have already noted, which place an exorbitant price tag on our clients' ability to seek safety and freedom in the US. It would cost Evelyn $100 per application, $500 in total to submit an asylum application for herself and each of her 4 children. With no assets or savings, in debt after fleeing her home country, with a monthly paycheck of $2,500, after rent, utilities, groceries, and other necessities for her family, she simply could not afford to pay these fees. But they cannot be waived based on inability to pay. If she did somehow manage to pay the fees, which are subject to yearly increases, she and her children would each be fined an additional $100 each year that their asylum applications are pending. However, given the increasing backlog of asylum cases in court, she would likely not be given a decision in her claim for years. She might not even go to court for years and have her hearing. Asylum seekers like Evelyn bear zero responsibility for the delays in our system, but they will have to foot the bill, even if that means more debt and less food on the table as they await their decision. And my colleague Cecilia noted that we are already seeing the effects of these fees on our community members. For months, we've been planning a pro se workshop with the goal of serving 25 asylum seekers in their applications for asylum and work authorization. There are 25 confirmed applicants, which have fled their countries because of persecution and fear of future harm if they were forced to return. Now they have to file their applications in a timely manner. This is the essential first step in requesting protection from the judge. However, we're faced with the possibility of having to cancel this workshop because these filing fees would be prohibitive for many of these families. For Evelyn, our former client, if we were to imagine that she entered the United States now, to work lawfully while she awaits the decision in her asylum case, she would need to pay $550 for a work authorization document, and an additional $275 for each renewal. And if any of her children are of working age, which one of her children was, the eldest, he would also have to pay an additional $550 for the work authorization, and then an additional $275 for each renewal. Unable to afford these fees to work, Evelyn's family would face hunger and homelessness. Her kids who entered the US as unaccompanied children would be subjected to officers' invasive physical examinations to search for alleged gang affiliation through tattoos. Not only potentially traumatizing, such searches would subject them to possible accusations of unsubstantiated gang involvement, blocking them from asylum eligibility. Immigration officials routinely mislabel individuals as gang members, often blaming victims of gang violence, including children. Next, the exorbitant funds and aggressive tactics provided for DHS enforcement would place Evelyn and her children at great risk of detention. While going to school or work, running errands in their community, going to church, and even while complying with their obligations under the immigration system, such as at ICE check-ins and even attending court, they could face ICE arrest. This is not a hypothetical. Just this past month, NIJC fought to release a mother and her children from ICE custody after they'd already survived weeks of family detention and been released and had already filed an asylum application. With the increase in family detention capacity, Evelyn's entire family would be at increased risk of detention. Profit, not safety, would drive this decision. ICE has already spent $159 million to reopen 2 jails for families run by private prison corporations, before Congress handed the agency $45 billion more to jail adults and families. As my colleagues explained already, their egregious overspending already paved the way for bringing civil immigration detention to heights we have never seen in US history. Imagine what will happen now that Congress is sending $45 billion their way. If detained, Evelyn and her family would be transferred outside of our jurisdiction, requiring our legal team to communicate with them remotely and with great difficulty to prepare for virtual court hearings. Their case would likely move to a jurisdiction governed by interpretations of immigration law that are prejudicial to non-citizens, before judges inclined to deny applications for relief from removal. Faced with the humiliating, degrading, and painful reality of ICE detention, she might very well elect to be deported to unbearable risks, giving up a meritorious claim to asylum. Luckily, Evelyn entered the US when she was no longer subject to remain in Mexico, before the current state of increased border militarization. She was not subject to a punishing tax on her ability to exercise her right to apply for protection. She did not encounter the added traumatization of detention that would have separated her from her support network, her lawyers, and her dignity. She was able to submit her full claim for asylum before an impartial judge who permitted her to present evidence and argue her case. Ultimately, the judge did grant Evelyn asylum, and her family is now on a path towards legal permanent residency and even citizenship. But our current and future clients do not face the same reality. The implications of this budget bill build upon the challenges we have already encountered over the last 6 months. We are prepared to fight on behalf of our clients, but our strategies have and will continue to evolve. Thank you. And with that, I will pass on the slides to Cecilia Mendoza.
Thank you so much, Stephanie. And can I please get the next slide up? Okay. Thank you so much. And we are grateful to all of you for joining us today. Each of us has something to contribute, and in this moment, I'd like to offer the following ways you can tap in as we navigate the challenging road ahead, starting with oversight and monitoring. We want to keep our elected officials informed of what we're seeing on the ground, and especially supporting our members of Congress to continue holding the Department of Homeland Security accountable for their unlawful actions and continue protecting everyone's due process rights. We also need to be working collectively to monitor and report ICE activity in our communities by making those reports to the Family Support Hotline. We know and have seen repeatedly that ICE continues to make unlawful, warrantless arrests, and we need to keep the pressure on and keep reporting instances of these activities in our communities to continue holding them accountable. For the attorneys in the room, you can take on a pro bono case. For full scope representation, it is one of the best tools available to help immigrants access due process. At NIJC, we always have asylum cases for pro bono placement with attorneys at law firms and corporations in Illinois and Indiana. If you take on a case, recognizing the roller coaster of changes your client will experience, pay for filing fees and other expenses as they arise. If you are not an attorney, you can volunteer your time, or if you're not in a position to provide pro bono work, there's still other ways that you can support. Volunteering your time could look like providing interpreter or translation support. You can also volunteer to accompany an immigrant to their ICE check-in or immigration hearing, volunteering at food pantries that serve immigrants in other ways in your community. We are also looking for people to be referred to our workshop for asylum. So in the chat, we'll also drop a sign-up sheet where if anyone is seeking assistance with their asylum application, they can fill out the JOT form so that they can sign up for consideration for one of our workshops. And then the last point I want to bring here is to donate to our organization and support NIJC's work. The new filing fees are prohibitive for many people, and many prevent them from being able to apply for legal status and achieve safety and stability in the United States. So at NIJC, we're launching a campaign to raise funds to help cover filing fees for the immigrants and asylum seekers that we serve. In particular, we have an immediate need for $7,500 to cover the asylum and employment authorization filing fees for 25 families joining our asylum workshop that we had already scheduled for next week before these changes were put into place. Without support, our participants may not be able to afford these fees, and NIJC would face the possibility of having to cancel the workshop. So please, if you're able to donate today, your donation would go directly to supporting filing fees for the people that NIJC serves. And there is highlighting that there is a QR code on the slide for you to scan. Just giving you a moment to grab that, and then I'm going to ask to go to the next slide, please. If you aren't already, we also hope that you will stay connected with us moving forward. Again, we are grateful to all of you for taking the time to be here to figure out how we can all work together to continue to defend immigrant communities. And I'm going to now hand it back to Charlotte to facilitate the Q&A section.
Thank you so much, everyone. And I just want to shout out that we have over 50 unanswered questions in our Q&A. We're not going to be able to get to 50 questions, but I'm trying to highlight the ones that I think are most relevant to folks here. Starting with you, Azadeh, can you speak to what have we already seen in the first 6 months of the Trump administration that will be worsened by this bill? Can you speak about that a bit?
I'll just share one case, which is that we've seen a number of people who have been subjected to what's called warrantless arrests, essentially, where ICE is arresting anybody that they come across, even if they're not the initial target for their arrest. We saw this in the Chicago area in violation of a long-standing settlement agreement. And individuals who have been subjected to those arrests and essentially sweeps by the administration are still sitting in jail 6 months later. That includes a father and a business owner named Oromo, who NIJC represents and is a plaintiff in one of our class action lawsuits. His wife is struck. Please, guys, has terms of, essentially ensuring that he's going to have his day in court and reunite with his family while his case is pending. So we expect a lot more of that with this bill and having passed, and people being arbitrarily targeted, charged, and essentially, left in jail indefinitely at the whim of this administration.
Thanks for that, Azadeh. Desi, I'm going to pass this next one to you. Can you talk about what comes next and how this bill fits into other ongoing legislative efforts by the current administration?
Yeah, it's really important to note that this entire reconciliation funding package is totally separate from the fiscal year appropriated funding. The appropriations process is still very much underway. Congress can push back against a lot of these policies, a lot of the funding that we're seeing through the appropriations process. So a lot of groups in coalition are using this momentum, this really broad opposition, huge popular opposition to this bill. This this reconciliation bill was incredibly unpopular. It barely passed. There were 3 Republican senators in the Senate that voted against it and it barely passed in the House. So using this momentum to push back on the appropriations process, also urging members of Congress to conduct unannounced visits to detention facilities. This administration is certainly trying to block and restrict that. Members of Congress have the legal right and the responsibility to conduct on-site visits, and we have a guide that we updated with other organizations, the Detention Watch Network and the ACLU, that we can share out as well, that provides information for members of Congress to conduct these oversight visits that are really pivotal in pushing back. And then, of course, for Congress to advocate on behalf of people directly, NIJC clients, and people who are directly impacted by these policies.
Thanks, Jesse. I'm going to stick with you for this next question, which is, I believe there was a new RFP for detention months ago. What is the timeline for that, and has it been awarded? And Jesse, if you could just also define RFP for folks here too.
Yeah, absolutely. So that was a request for proposal for new detention facilities. But what we saw actually in April, there were new solicitations out for new detention contract awards. It was initially for 45 billion that ICE was trying to award new contracts. It was later reduced to around 10 billion, but it's definitely worth noting that that number they were initially proposing is the same that they got in this reconciliation package, the 45 billion for new detention. So out of that solicitation, we do know that the North Lake facility in northern Michigan in Baldwin, the massive Geo Group prison that reopened as an ICE jail with 1,800 beds, that is actually also in the Chicago area of operations, that came out of that proposal. We expect to see more of these come. There are still really intense fights against the opening of new jails, but we expect more of those requests for proposals and solicitations to come out. And we certainly will be mobilizing and working with communities to push back against those.
Thank you, Jesse. Azadeh, I'm going to send these questions about the fees back to you. There are a lot of questions about fees. We're not going to be able to answer them all, but just a few to highlight. Whether there's a fee waiver for SIJS, if derivatives on asylum applications also have to pay the $100, and what to do about asylum applications already in the system. Maybe start with those three, and then I'll give you a few more.
That sounds good. Yes, there is a fee waiver for SIJS, or Special Immigrant Juvenile Status. That is one of the last changes that was made to the bill. So that is available, and it applies to all kids who apply for SIJS, regardless of whether they are reunifying with a parent or not. Regarding whether or not families, for example, a mom and two kids who are applying for asylum together would be charged $300 or $100 if they are applying under mom only. To be honest, that question is a bit unclear. Like the statute doesn't spell out what happens in that particular circumstance. So, and there are strategic calls that attorneys have to make all the time about whether children should have their independent asylum application as well. So, all of those things raise the question of basically put the burden on applicants to be ready for being charged more rather than less, given the lack of clarity that we have at this juncture. The $100 per year that an asylum application is pending kicks in right away. So we don't believe that there is language in the bill that permits retroactive application. That doesn't mean that the agency isn't gonna try. But right now there is no particular language as to retroactive application in particular. I think that those are the questions, but.
Thanks, Azadeh. And a few more on the fees. What happens if someone can't pay? And what do we do if fee schedules aren't updated online?
I'll take the last one first because it's a little bit it's a little bit tricky, but so right now basically there's two different places where people can pay a fee. It can be with USCIS if their case is pending there, in what's called the affirmative process, or with the immigration court if their case is pending there. We understand that USCIS has not updated their fee schedule. However, the language of the bill is abundantly clear that this fee is essentially going to be in effect right away. So that means that the lack of infrastructure or mechanism for receiving those fees or filing them on, providing them online does not mean that the applicant is relieved of the burden of providing those fees. So we expect that people are going to see rejections, even if it's not their fault and it's really the government's fault that there is no infrastructure for receiving the fees. And that could be the case as well at the immigration court level. And I'm sorry, the other question that you mentioned, Charlotte?
The other question is what to do if someone can't pay?
That is a huge question. We expect that, again, because now they have actually changed the statute, for example, for asylum. That means that, it's a requirement for people to produce those fees in order to proceed with their asylum case. We expect that that's going to mean denials of meritorious asylum applications if people are unable to afford the fees. Whether or not that means the government is going to crack down on folks who can't pay, that's another question. But Stephen Miller has already indicated an interest in coming after the property of people who are unable to pay certain fees or have outstanding fees. So there could be more on the horizon in that respect.
Thanks, Azadeh, and thank you to all of our panelists. We are at the end of our hour, so I just want to thank everyone for joining us today and for the advocacy many of you are continuing to do to defend immigrants and other communities who are affected by this bill. It's obviously a very troubling time, but we're heartened and grateful for the solidarity that we feel as we continue to fight back against these harmful policies together. Please look out for a follow-up email from NIJC that will have both a recording from today's presentation and also an updated explainer about the impact on immigrant communities. And we will continue to be in touch as we see more how this bill and others unfold. The work obviously continues, but we're really grateful to be doing it alongside all of you. So take care and thank you so much.